I welcome you again to the Elite Law Training. My name is Folakemi Jegede, and I'll be taking you on today's episode. But firstly, thank you so much for your comments and feedbacks in respect of our last post, where we spoke on the introduction to criminal law practice in Nigeria. And if you haven't listened to same, kindly do. Today, we are going to be looking at the role of a defense counsel in the administration of criminal justice system in Nigeria and basic guideline in criminal litigation. Kindly note that there is a logical nexus between a legal representation and a fair trial. Even the common law recognizes that it is fundamental for an accused person to be represented legally and to also be advised legally. So, the Constitution of the Federal Republic of Nigeria, particularly Section 36(6)(c) of 1999 as amended, provides that an accused person has a right to a legal practitioner of his or her choice. And this provision is available also in the Constitution of other countries. For example, Section 25 of the Republic of South African Constitution also provides for same, and the 6th Amendment of the United States. So, as a legal practitioner who represents an accused person, he or she must make sure he performs his role and adhere to the ethics of the profession, bearing in mind the duty that you owe your client and also that you owe the court in the course of justice. Even though we don't have express provisions that guide us as a defense counsel, but the rule of professional conduct, particularly Rule 16, states that a legal practitioner must be competent enough to handle the matter he has been engaged to do. In United States of America, it has been judicially noticed that an accused person should not only have a right to a legal practitioner to defend him, but also to an effective defense counsel. Therefore, it is very sane for us to know that at every point of a criminal proceedings, there is a need for an effective defense counsel. We will be putting all the roles of the defense counsel under this umbrella, that a defense counsel must be an effective defense counsel. And what does an effective defense counsel entail? Number one, an effective defense counsel must be able to evaluate options available for their client and also inform the client the consequences of each option. A defense counsel must be able to determine the success or failure at trial depending on variety of factors such as the defendant's records, the facts of the case, the prosecutor's personality, the prosecutor's willingness to go to trial, the judge's reaction to certain types of crime, and the precedent in terms of prior disposition for this type of offense. My friends, this is very important. It will help you to evaluate the options and take decisions that is the best at a particular time. And number two is that an effective counsel must be able to negotiate and communicate effectively. You must have great advocacy. You must also be able to negotiate better, even very well. That is, bargain around severe collateral consequences that the defendant wished to avoid. Another role is that the defense counsel also owes the client to properly inform them of every information, every details that comes to them, so that the client will be abreast of what is going on in his case. In the case of Obetan against the state, 2007 All Federal Weekly Law Report, Part 376, is a court of appeal matter, and in that case, it was held that a defense counsel owed the client to do that. So another rule is that you must allow your client to take decision voluntarily that is voluntariness of your client. Don't load any options on your client. The best thing that you can do as a counsel is to place all the cards on the table, tell them the implication of each and every one of the cards, and allow them to take decisions for themselves. Another rule is that you owe the court as much as you owe your client. You are a minister in the temple of justice, so anything that you are going to do must be within the ambit of law. You must not cut corners. Save your head before you save your client. It's very, very important. And the last point we are going to be talking about on the role of a defense counsel is that you must be competent. You must be competent. Don't engage in a matter you don't know. The best that you can do is to find somebody to help you out with it, or seek knowledge. It is very important. And remember, you are not just a legal practitioner. You must always be an effective and a competent defense counsel. Considering the basic guideline in litigation, the first step that a defense counsel must do is to go through the proof of evidence to be very sure that the requisite provision has been followed. First of all, look at the charge in line with the sentencing provision. Then, you will now be able to know the options to follow. Number one, it can be to file a preliminary objection. It can be to plead to the charge. The reason why I'm not talking about plea bargaining right now is that plea bargaining should be your last resort. It is when you've seen the proof and you've gone through it and you know the case of the prosecution is watertight before you cut any deals. And always remember, it is for the prosecution to prove their case. Your client is still presumed innocent until proven guilty. So know when to do that. Alright, so after you've gone through your proof of evidence and at the point of arraignment, you should know if your client will plead guilty or not guilty. So in preparing for trial, make sure you've prepared your questions using the statements and the proof of evidence. For each prosecution witness, and also be abreast of the evidence act, particularly the relevancy and admissibility of exhibits that may be sought to be tendered during trial. Be strategic. Know the ingredients of the offense your client is being charged. Your purpose during trial is to focus, to puncture the evidence of the prosecution witness or to discredit their testimony. Don't ask irrelevant questions. Focus. Even if you are asking any other questions, it should be to destroy the ingredients of the offense. That means have a target. Know why this is very important? It is because all ingredients of the offense must be proved to sustain conviction. And if the prosecution is not able to prove it, that means your client will be discharged and acquitted. And if not, even on appeal, you will know that you've done what you are supposed to do at the trial court, and this will give you a better stance there. So, my dear, it is not about you. It is about your clients for you to get the job done. Thank you for joining us today. I hope you have learned something. Kindly send your comments and reviews to our inbox on Facebook at Folakemi Jegede and on Instagram at Folakemi Jex. To download this audio, please subscribe to our YouTube channel at The Law and High. Thank you very much.